All rise. The Honorables, the presiding judge and judges of the North Carolina Court of Appeals. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good afternoon and welcome to the Court of Appeals. My name is John Tyson, and your panel today, to my right is Judge John Arrowwood, and to my left is Judge Fred Gore. We have one case on the docket for argument this afternoon in the matter of McClatchy Company et al. I'd like to introduce the courtroom. Mr. Roderick Farland opened court today from the clerk's office, and Mr. Richard Vermilliard is our court marshal. So, are there any preliminary matters to come before the court?
None from us, Your Honor.
Okay. Hearing none, then we will hear from the appellant.
Thank you, Your Honor.
Mr. Biller.
May it
Welcome.
please the court, my name is Tony Biller with the law firm of Envisage Law. At counsel's table with me is my associate Adam Banks. We're here today on behalf of the city of Graham and its police department. Your Honor, if it pleases the court.
Did you sign the brief?
I signed the reply brief and my colleague signed the appellant's brief, Your Honor.
Okay.
If it pleases the court, I would like to reserve 15 minutes of my time for rebuttal.
15?
Yes, Your Honor.
Okay.
Your Honors, as set forth in the brief, this is an appeal from North Carolina General Statute 132-1.4 AG, the statute governing petitions to release custodial law enforcement agency recordings. Custodial law enforcement recordings are not public records, and the statute sets a fairly rigid and in-depth procedures or policies for whether and when law enforcement recordings may be released. Before you,
But isn't it true that it gives the trial judge substantial discretion in the statute itself? It uses the word discretion, does it not?
it does, and we think we have two issues before the court. This is a case of first impression. In fact, there's only one other case published on the statute, and the statute itself is of relatively recent vintage. The two issues that I believe are before the court. The issues in the brief, I think, can be distilled largely into two categories or issues. One is an abuse of discretion, a legal standard. One is a de novo legal standard. The second is abuse of discretion.
Where do you get de novo anywhere in the statute?
I'm sorry, Your Honor?
Anywhere in this statute, where do you find a de novo review?
The construction of the meaning of a statute is de novo. The application of the statute to the facts is an abuse of discretion. In this case, we believe it's a de novo issue of how the court applied the burdens of proof.
Is there any language in the statute or in any case law that says this is a de novo review, sir?
I don't have the cases memorized. They are in our brief. The allocation of the burden of proof is a legal question that I believe is de novo. And I'm sorry, Your Honor, I cannot recite the name of those cases
But
to
that's
you.
not with respect to this particular statute that talks about discretion, is it?
I don't think that every issue that arises under a statute is necessarily dictated by only the words used in the statute. Most statutes don't set forth the mechanisms by which a court reviews and interprets a statute. This court should review de novo the legal meaning and consequences of the terms and the procedures in the statute. How the trial court applies those, Judge Arrowwood, is a matter of discretion.
So, counsel, I'm sorry to cut you off. I know you're trying to address, but I'm wanting, before we get too far down the road, so your interpretation of us looking at it de novo is because of the, I guess, the structural interpretation of the statute versus the application. So are we at a constitutional challenge of the statute versus an application challenge? I just want to make sure I'm understanding, because I didn't see a constitutional challenge to it being as applied.
No, we're not making any constitutional challenges.
Okay, so I'm just making sure, get back to that delineation of how you.
So I'm halfway through the first issue.
Okay.
The first issue, we believe, is de novo. And as this is a case of first impression, I think phrasing or characterizing the issue is challenging because it simply has not been interpreted, at least not in this context, whether and when and how a court should order the release. The issues that we think are de novo, Your Honor, are the burden of proof / the standard, or I should say, accompanied by the standard for satisfying that burden of proof. We believe that is a question of law, not a question of application at the sound discretion of the trial court.
Mr. Miller, do you draw a distinction between recordings, for example, made by a body camera when an officer's in public, as opposed to a recording of an interview at a police station, or where a potential suspect is being interviewed? Is there a difference between those two situations?
Not for the purpose of this first burden of proof standard. When you get into the application of the factors, which I believe Judge Arrowood is alluding to, which is the second part of error in this case, no. We don't think there should be bright line categories for what gives rise to, or at least per se, privacy interests or not. The newspapers.
So if something occurred in the public with witnesses around, and the camera is merely confirmatory, as opposed to having a suspect in an interrogation room?
It would depend on the particular context. And this is why the
So is the request they're offering, is it for all and both of those? Would it include both ones that were body cam from the officers in addition to ones that may have been from suspect interviews or interrogations?
For the city of Graham, all of the newspapers' requests implicated body cams.
Only?
No. Almost entirely. There were 24 body cam recordings and I believe 4 poll cams. For the Alamance Sheriff Department, there was drone footage and a lot of individual still shots, no body cams. So back to your question.
But this is not a question in a case about interrogation of someone in
Correct.
in a room. There's
It is
none
not.
of that
No.
involved in this case.
But the context of privacy has to be contextual. Because I am a police officer standing at a public event does not mean that my sidebar to my fellow officer, Mr. Banks, is a public comment. In fact, we have to remember that these body cams are attached literally to the body of the police officers. And because I might be able to be seen by your clerk from 100 feet away, she and nobody else knows what I've communicated to the other officers. So I think the question of what's private, what's public, depends.
Are they voice or motion activated or both?
I think they're both, Your Honor.
So when someone starts speaking, it will start recording, or if there's movement, they will start recording?
Not if there's just movement. I think there's a physical switch, and I believe they can be voice activated, but I know they can also be turned off. So in this case, you have the better part of 30 officers that had cams on. The duration covered by the request is over 5 hours. Just the city of Graham, you have over 30 officers, but you don't have 30 times 5 hours of footage. In fact, you only have 55 hours of footage that fall through the entire event. Now, if the courts will, because this is a matter of first impression, I'd like to get back to what we believe the two issues are before the court. The de novo issue, believe, is did the trial court err in ordering the Graham Police Department to collect and list specific objections to producing a corpus of videos when the petitioner's compelling public interest was the general interest of law enforcement transparency?
Well, you talk for a long time in your brief, or in the principal brief about how, you know, that they should be able, that they should have to ask for specific things. How are they supposed to know what the specific things are in your body cams?
Well, they need to be something more specific than a 5-hour span of times when officers.
Where in the statute does it say that?
It says
It says the date and time, does it not, sir?
the request for release must state the date and approximate time of the activity captured in the recording, or otherwise identify the activity with reasonable particularity sufficient to identify the recording to which the action pertains.
Date and time, which is what I asked you, and that's exactly what you told me it said, didn't it?
There's a date, there is no time. There is from when police officers first encountered a protester, a member of the media, or a spectator until such time as the officers were released from the event. That spans 5 hours and approximately 40 individuals, Your Honor.
And you didn't have any problem identifying and providing to the judge in camera the things that covered that time?
Absolutely incorrect, Your Honor. It took a substantial amount of time from
But
a
you
small police department and a small phalanx of attorneys to go through on just one small police department's recordings what was responsive to this request. It was a substantial and involved and very expensive endeavor, which we don't believe the legislature anticipated with this statute. But again, we are not necessarily saying that issue right there is de novo. What we're saying is de novo is who has the burden of proof of requiring a police department to come forward and make this type of effort, a municipality. The burden of proof, in this case, the opposite side of that coin is the issue of the legal standard. The legal standard invoked by the appellee, by the newspapers, and relied upon by the trial court was the desire for transparency of our government institutions, the transparency of law enforcement. We respectfully suggest that is not a compelling or a substantial public interest justifying shifting the burden to the police department. That is the public policy that undergirds this statute. On the one hand, you've got the desire to promote public transparency. On the other, you want to protect privacy, security, and internal operations. So simply invoking the public policy of the statute should not be enough to shift the burden. If that is the case, if that is sufficient, then the burden automatically will always rest with the government, and the burden will shift to always justify not producing the videos, and that's not how this statute is written.
If a public officer, either a sheriff's deputy or a police officer, is on duty in uniform performing official functions, does the public have a right to see that?
No, he does not. I'm sorry, does he have a right to view the officer in the public performing his or her functions?
Well, that's the first question, yes.
You have a right to observe anyone in a public space, Your Honor.
Okay, and more particularly a public official. Do you agree with that?
Yes, Your Honor.
So why is the mere recordation of those actions of what could be freely viewed, why is that subject to any protection at all? I'm talking about the public action, I'm talking about private conversations.
Well, for two reasons, Your Honor. One, because the legislature said it is. They said this is not a public record. They moved it outside the scope, and every court up through the United States Supreme Court has agreed these are not public records. These are records that are only disclosed at the discretion of the legislature, with the court sitting as the gatekeeper.
Do you agree that the amendments liberalized the release? They made what was formerly very difficult to release or to get more readily available. Is that a fair summary of the amendments to the statute?
The most recent amendments from the past year?
Yeah, well, since the statute was first,
Yes, this statute is presently codified, does provide for a more reasoned means for releasing those. And the reason I don't say absolutely there's a right to obtain those videos is because the legislature has said there has to be a compelling public interest. If I'm standing at an intersection as a police officer, for whatever reason, with my cam vest going, doing nothing, there is not a compelling public interest to have that cam vest. If I'm doing something, perhaps I'm interacting with the public, but I have side conversations that are heard by nobody but my fellow officer, then I think there's a different standard. What were those private conversations? I'm in a public venue doing a public act, but I'm having private conversations in the course of my law enforcement duties. Then the court has to step in and say, is there a compelling public interest for invading this private conversation?
So, Counselor, go ahead. You start.
Where in the statute does it make the distinction between whatever your client said to someone else? Are you saying if they had said it to the public, it would have been under this, but if it had been to another officer, it would have been a different standard? Is that what you're saying?
The entire context of the statute is to balance, on the one hand, public disclosure and transparency, and on the other, the privacy rights of
Go ahead. I'm
the
sorry.
privacy rights of the officers, security rights, health and, safety rights.
And it gives the trial court the discretion to make that determination, does it not?
It gives the trial court the discretion to make that determination once a compelling public interest has been shown. And talismanically invoking the public policy for this statute is not, we believe, in the context of how this statute is written, a compelling public interest.
What's your authority for that?
That the public, because if it was, the first articulated factor would be entirely superfluous, and the legislature would have said the court should produce these unless it finds elements 2, 3, 4, 5. You've created the very first factor issued is surplusage. And then after those factors, what's it say? And this, Judge Arrowwood, is the second issue we think before the court.
I want to tell you into your
I see that, Your
reserved
Honor.
time, and Judge Gore did have a question.
I just have one question, very succinctly. It sounds like, from the context of the first half of your argument, even though you didn't get to your second issue, is that the contention is, and the more sensitive issue at hand, potentially is the conversations that were had and are deemed to be argued by you and to be the privacy of those. Because is there an issue or is there an argument if we were only dealing with drone footage that would not have any audio? And I'm curious to hear your argument on that, because the issue at hand, and maybe some of those conversations sounds like is what is trying to be addressed. Would you have an argument, or would there be a fight if we were just talking about drone footage with no audio?
Yes, and we have been rabbit trailed respectfully, Your Honor. I've allowed my argument to rabbit trail. This is not about who said what to whom between the two agencies, the better part of 100 law enforcement officers, and 5 hours and hundreds of hours of different types of recordings. That's not what this is about, at least not in the first instance. There's a more fundamental problem. Can somebody walk into the court and say there's a public interest in police officer disclosure and transparency? I want all of the recordings from an entire day. You pick the topic. I don't care how large the event is. And then sit down. The burden then shifts to that municipality to compile it all and then to record it and list the objectives. Does it shift that easily? That's the first fundamental question. And it's not just an academic one. There are hundreds, there's at least 99 other sheriff's departments and an equal number of police departments that confront these daily. My colleague stood up before the trial court and said, admits on the record, We wrote these intentionally broadly because we don't know what's out there. That is not how the statute's supposed to work.
How are they supposed to know what's out there?
If you don't know what's out there, then respectfully, you don't have a compelling public interest.
But
in this case, they did know what was out there.
Do not have a compelling public interest to know what the police did when they were arresting people in a march on voting rights.
Then you know, Your Honor, you've just impeached your own question. You know what is out there. In this case, I have a compelling public interest to know this civil rights leader interacted with Deputy Tomey. She fell to the ground and was injured. That's a public leader, a public law enforcement agency. They've both given very different statements with what happened. We want all footage about that confrontation between Gregory Drumright and Barbara Tomey. You do know what happened. You can ask for it. My client can come down and do a succinct search. There is a compelling public interest, but simply walking in and saying, I want all footage, which is essentially from 8:30 a.m. to 4:30 p.m. over a 1 mile square, is simply the wrong legal standard.
Counsel, by itself, I understand your argument, but with in-camera review by the trial judge, doesn't that help filter through that argument?
So remember I said the first issue, there were two subcomponents. We've only gotten through the first component of the first one, the upfront threshold, whose burden and what is a sufficient standard to trigger the burden shifting. Talismanically saying transparency shouldn't be enough to make a municipality go through hundreds of hours and make a judge sit through 55 hours to see if there might be something there. The second part of the burden we have in this case.
So as I understand your first issue, there's got to be more than a fishing expedition, is your
More than a fishing expedition, more than a talismanic recitation of the public policy underneath this statute.
You're under 10 minutes, so I'm just trying to help you keep a track of your time.
My intent to say what the second issue is before I sit down. I'm still not through the first issue. Part of that burden is once the court does its in-camera review, it decides what to produce. And in this case, what did the judge say on the record and in his order? The law enforcement agencies failed to provide a compelling government interest for censorship. That is not the standard on the last paragraph of the statute for what should be produced. It said the court shall produce only those portions that relate to the compelling public interest. By characterizing it as...
Actually, what the statute says is the court shall release only those portions of the recording that are relevant to the person's request and may place any conditions or restrictions on release of the recording that the court in its discretion deems appropriate.
Yes, and the request must be for a compelling public interest. In this case, the judge completely flipped it around and said the burden was on law enforcement to say what should not be produced. Again, the burden is backward. Now, the second issue, Judge Arrowood, I think you'll find this one more acceptable, is when the court goes through its calculus, should the court identify the harms set forth by the statute, which in this case the trial court did, said there was a potential for harm to reputation and the jeopardizing the safety of a person. When the trial court finds those harms, is it incumbent or is it an abuse of discretion when the trial court refuses to take any mitigating measures against those harms or fails to give a reasoned opinion for doing so? It's an abuse of discretion standard, but when the trial court says it has found these harms, is it an abuse of discretion either not address them or explain why it hasn't? Thank you, Your Honor. I say I have 7 minutes and 30 seconds remaining.
Yes, thank you. Thank you, Mr. Biller. Mr. Tadich?
Toddy, like a hot toddy.
Toddy. I'll do the phonetic spelling then.
I'm sure that happens more often than it does not.
Okay.
May it please the court, my name is Mike Toddy from Stevens, Martin, Vaughn, and Toddy. I'm here on behalf of the petitioners, as is my colleague, Hugh Stevens, mentor and colleague and friend. It's a pleasure to be here before you this afternoon, as always.
Good afternoon and welcome. Mr. Stevens, welcome to the court.
Judge Airwood, you asked about the standard of review and is this de novo or is this abuse of discretion? It's absolutely abuse of discretion. But before we get there, I have to remind the court that Mr. Biller's first argument about de novo review and burden of proof and everything was based on the judge's order from March 8th, 2021. That order has not been appealed. And as Judge Airwood, you recognized, while it was difficult and perhaps cumbersome to gather up the recordings that we requested, they were able to do it without any trouble, is that we identified that which we were requesting. I respectfully disagree with Mr. Billett that the threshold is there a compelling public interest? That is one of the 8 statutory thresholds that the legislature said the court shall consider. In addition, the court can consider anything else that they deem appropriate. Here, Judge Hanford, in making his order, said that it was paramount and he gave great weight to not only transparency, but accountability of law enforcement's interaction with the public. Now, a few months ago, I was in trial court with Judge Bedour on one of these very hearings, and he said, Mr. Toddy, are you telling me that any of law enforcement's interactions with the public are a compelling public interest? And I answered that in the affirmative. They all are. That's what we've been talking about since 2020. These cameras exist on on-duty public officers doing their job, and Judge Tyson, you mentioned about what is private about them doing their duty, and there's nothing. Anything that can be seen in public is recordable. There is no exception under the statute for a private conversation. And Judge Gore, I think you hit it on the head. Part of what has been released, because it's been recorded otherwise, are unsavory conversations among and between law enforcement. And that's part of what we're looking at. I started this hearing with Judge Hanford saying, we're not here to indict or vindicate law enforcement, and we're not here to indict or vindicate the protesters or the bystanders. We're trying to figure out what happened. So one of the 8 standards is compelling public interest.
Do you think there's a compelling public interest to have video recordings of the U.S. Supreme Court?
I do.
But those are not allowed, are they?
I understand, and the court has set those rules. You don't know
So the
this.
fact
Go ahead.
that it's a matter of high interest and it's a public matter, that does not ipso facto create a right to a video recording of that public argument or that public proceeding. Is that correct?
I agree with that, Your Honor. I think that here the legislature has set up, and as you were alluding to, prior to 2016, it was sort of a catch as catch can.
It was almost a blanket prohibition under the original, or very difficult.
It was difficult in that the argument was these are law enforcement records under the Public Records Act, and thus they're not public records. Or this is a personnel record, and thus they're not public records. Mr. Stevens and I argued one of these in Alamance County, and we were denied access to the recordings. As we drove back through Chatham County to get back to Raleigh, a different judge released an officer-involved shooting recording, all before this particular statute was there. So I agree with you. It is the method that the legislature set out at these 8 statutory factors that shall be considered. Judge Hanford considered every one of them and then added his own about the transparency and accountability of law enforcement's interaction with the public. The abuse of discretion standard, as is cited in our brief, is very high. And not only do you have to show that there's error, but you have to show that there's prejudice created by that error. I have not seen, my clients have not seen from the release any of these recordings. So we believe there is no prejudice that's set forth in the record. The appellants haven't shown any, and we don't believe any exists. With respect to...
Are you contending, excuse me, Ms. Dottie, are you contending that private conversations between officers themselves would be subject to disclosure?
Your Honor, if they're discharging their public duty and they're in the public streets of Graham and public sidewalks of Graham and public property of Graham, I don't think there's any such thing as a private conversation. If
they're in a squad car together?
Again, it depends on the circumstances, but in the context that we have, I don't believe so, no. There is a method for them to turn off, and from my experience with these, there's a button on the front that they can turn it on and off, and that's what they can do. I do not believe any of them are motion activated other than the dash cams. In addition, it's our understanding there were security cameras and drones And so all of that encompassed our request.
So you don't make any distinctions between, for example, what Judge Gore said was the drone footage with no audio and a conversation that could be just between two officers communicating just between themselves? You see no distinction?
And I don't want to be so absolutist. Yes, I can find a distinction.
Well, we're just trying to get the guardrails here.
And I appreciate that, and Mr. Stevens and I talked at some length about why we're having this hearing, because we think the legal issues are concrete and dealt with in the briefs, but it's very interesting. It's all very interesting. I can't remember which of you, and maybe it was you, Judge Tyson, said the in-camera review process will shed light on that particular issue.
I believe that was Judge.
Okay, and so if in going through the recordings that, met the request, the in-camera review, and
So that is a guardrail.
it may be, well, that's one of the safeguards is sure, the in-camera review. It may be, although the doing an in-camera review under the statute appears to be discretionary, it may be argued that it's an abuse of discretion not to, because there may be, let me give it a different context. We have had situations where there's been an officer involved shooting. It has been in public vantage point, but the son of the person who was shot and killed was standing next to them. I wouldn't have known that because it happened in the middle of the night in making those requests. The judge in reviewing that said, I don't need, the world doesn't need to see the little boy who's standing next to his father who has been shot. And that's part of the process. And so the judge invokes that discretion and blurs that out. In this particular hearing, and you have the entire transcript, neither the sheriff's office nor Graham police argued for any of those particulars. The only particulars that they argued as far as a X to Y timestamp is the arrest of Tom Morawski, the arrest of so-and-so, the arrest of so-and-so, without saying there's a private conversation between Officer A or Officer B about something that was not related to the public matters.
I think, if I understand, Mr. Biller's argument is, can you just make a very broad request and then put them to the burden of having to shift through voluminous data? Or are you required under the statute to be more specific in what you want and tie it to a specific event? I think that's probably the first issue. Can you do a fishing expedition, for lack of a better word, then expect them to have to go through everything to find out what may or may not be relevant?
So what and Judge Airwood read this portion, the statute says the request must state the date and approximate time of the activity captured in the recording, or otherwise identify the activity with reasonable particularity sufficient to identify the recording to which the action refers.
So a 5-hour ban within 1 mile meets that request?
We did not give the geographic scope we asked for in the petition, which is in the record. It's very early on in the record. We basically said from law enforcement's first encounter with the protesters until the scene was cleared. I don't know, even from all of my clients' reporting, I don't have that time stamps. I know approximately based on what I had. It appears that it was about a 5-hour period of time. But I only know that from the submissions that the court required. Again, the court required the government or the Graham Police Department go through and state the portions of which the recordings to which they had objection and their reasons for. Even if he had not done that, under the process that the AOC set up in the form order that's in your record, they would have to go through all of the recordings and identify all of the police officers who were depicted, whether by image or voice, in these recordings and give them notice of the hearing and the opportunity to be heard. No police officer from Graham PD that is among those that are listed as having worn body cameras showed up at the hearing. No sheriff's deputy or sheriff showed up at the hearing. And so we've got Graham Police arguing a privacy right, apparently of its officers, that may be related to something that is not their official duties. I think that's one step removed. And in fact, they didn't actually argue that. They argued that none of this should be released because of pending criminal matters, or that they don't believe there's a compelling governmental interest or compelling public interest, or that it's no longer newsworthy. Well, the compelling public interest, we believe we've satisfied, and so did Judge Hanford, but that's not the threshold to get here. The threshold is you make a request. If they can identify the recordings, They have to go through them and identify the officers that get notice, and then it goes in for in-camera review. I gave Judge Hanford this example, and it's in the transcript. WRAL requested all of the law enforcement recordings from the Durham gas explosion. It ended up to be over 100 hours. I'll tell you exactly what I told the court. What we understand is there was great heroics. We don't know, by law enforcement. We didn't know what time or where, and so we asked for all of them, and the court granted them without redaction. And so that's over 100 hours. This is 55 hours. We didn't set up this process, but it works in the end. Yes, it takes up an enormous amount of court time. If it were me writing the statute, that they would be presumptively open, and we could argue about the instances where perhaps they shouldn't be released.
So, Mr. Toddy, on the issue that Judge Tyson brought up is guardrails. Would it be fair to say, and I would hope this would be fairly succinct, officers are on the beat, they're in the patrol car doing their duties. They stop, they go off duty to get lunch. They're still having conversations, body camera's still on. They're not doing an official duty, they're in, Applebee's getting lunch. Is there a distinction there between that private conversation at that point versus when they're in a patrol car or they're walking a beat because of the duties that are being performed and then the lack thereof? Can you talk on that?
I can try. What I understand you saying is clearly if they're, having lunch and they've left their body camera on, well, A, I think they'd be violating their department policy. B, it really depends on what the conversation is. If we're only having lunch and we're talking about the NBA finals, that's one thing. If they're talking about something else, and I think that's where the in-camera review comes in, where the court says, yeah, you were at lunch, but here's what you were discussing, and that's part and parcel to the particular public event on-duty thing that you were doing. I think it's also fundamentally different than, and we've had these situations, somebody goes in to serve a search warrant, and, things go crazy. That homeowner, even though there's a warrant, has a recognized privacy right. None of the appellant's briefs state any citation that there is a expectation of privacy in public in North Carolina or elsewhere. It just isn't there. And so to engraft one, to set a guardrail that doesn't exist, I think, is dangerous. I think it's also important to point out that in making these requests, it's not we're only seeking the salacious. Part of what our clients do is hear the police did us wrong. They request for the recordings, and it may show that that's not the case. It may show that it is the case, and it may show that it's unclear. But one of the ways that they can get to the bottom of the story, based on what our legislature has set up, is to get these recordings. I absolutely agree that the legislature could have said, these are records of criminal investigation. And under 132-1.4, no large A, they're not public records. They didn't do that. They're a hybrid. They're something in between. Elsewhere in the public records law, you would be arguing about, well, yes, they're public, but there's a mitigating circumstance that there shouldn't be. Here, we're arguing the inverse. But I will say this, even under 132-1.4, no large A, but on parens A, a court of competent jurisdiction can release law enforcement recordings, or law enforcement records, and there is no standard. Here, there's a standard of abuse of discretion. It's discretionary. In that particular context, there is no case law that says what the appropriate standard would be. We believe that appropriate, A, the arguments that go to the March 8th order and the scope and being ordered to produce the records or to review the records and tell them where they object, that's water under the bridge. They have not appealed that argument. And so none of that is there. In addition, there are a number of arguments, as we pointed out in our brief, that just simply weren't raised below. They were new in the motion for stay context, and they're not properly before you. Third, we believe that you should uphold Judge Hanford's decision and affirmance and dissolve the stay and order their production.
Well,
Go ahead.
let's talk about, you say that they're not preserved below. They did file an objection with a whole line of objections to various items, as I recall, that's in the record. Why does that not preserve their arguments?
With respect to what part, Your Honor?
With respect to anything that they've objected to on, let's see, they've got,
I think it's at the record at 208, Your Honor.
yeah, the 208, they've got all of these objections. And I'm sort of struggling with you saying they haven't preserved their objections to the release of those things.
I do not see that they have objected to the court's order requiring them to do what the court ordered them to do, and they complied with. If it's in there, I have missed it.
So you're saying they didn't, so it's your argument that they would have had to have noticed appeal to that order in order to raise the scope of what they had to give to the judge?
The substantial interest test, I think, is what we're touching on. I never seem to understand where that bright line moves. But I will say that they could have, because as Mr. Biller has pointed out, it took them some time. They may say that these resources, that's a substantial hardship, and they could have possibly noticed an interlocutory appeal and fought that out and met that burden that they were probably before. But even if they didn't, let's say that was water under the bridge, when they filed their notice of appeal, they could have also appealed from Judge Hanford's March 8th order, and they didn't. And so I don't think that's properly before you. It may seem overly technical, but I think that's the way we're supposed to approach these things, is what are we arguing about? And that, I think it's Judge Hanford's order and what he did. The last thing I was going to say with respect to Judge Hanford's order, that he talked about not having the authority to censor these things. As we say in our brief, I believe that was engendered by my commentary that I think the process the legislature set up, there's an argument that they create judicial records by having them brought into the court, ordered into the court. I understand the counter-argument that they're in camera and they're not judicial records. But the context in this case is different, because what they did argue is there are more than 20 arrests, and there were 2 federal lawsuits, and certainly, and he didn't articulate this, but I could see Judge Hanford saying, I'm not going to restrict the release of these records and possibly affect a judge in the criminal context or the other civil contexts, and so I don't believe I have the authority. But let's say he was wrong on that. It doesn't matter, because it's an error without prejudice. It's an error that has done nothing to prejudice the appellants whatsoever.
Well, but does that in any way say that he didn't exercise his discretion in releasing them by saying that?
Your Honor, no. I think under the abuse of discretion standard, the appellants could have asked for additional findings of fact and conclusions of law. Clearly, he went through the process. You can see the form in the record in front of you. And if those aren't sufficient, and I think it's the Behringer v. Wake Forest University Baptist Medical Center case, says the court's not going to presume prejudice. And so if the findings of fact and conclusions of law aren't sufficient, then we're going to presume that there was enough there in front of the court that the court's decision was met by, properly exercised the discretion. It's on the burden of proof on the appellant here to demonstrate not only an abuse, but that there was harm, and I don't think either are present.
So if there's an argument to be made that for whatever reason the trial court didn't use its discretion because it felt like it could not, isn't that within itself is something that this court should review? If he's saying right here that he doesn't feel he could censor it, and so the question is, are we sure that Judge Hanford used his discretion?
I believe under the Behringer case, it's presumed that he did. I think he went on to say, and I recalled reading the transcript, and he asked me to draft this order. He went on to say that the court gives great weight to transparency and public accountability of police action, and failure to release the photos, recordings would undermine the public trust and confidence in the administration of justice. I'm not a judge, but that sounds discretionary in its context. This was a WebEx hearing, and so it was a little difficult to follow at times, but I think he went through the whole process that the statute requires. I think that the order is evidence of that, and the appellant's burden is to show that he abused his discretion. It's cost them harm, and it's not there. And that was part of Mr. Stevens and my discussion about this seems apparent to us, and I don't mean to be presumptive. I'm happy to answer any of your questions.
Mr. Toddy,
Sure.
aren't there cases that says that the failure to exercise discretion is itself an abuse of discretion?
I agree, but I think
We've seen cases where the judge says, I don't have the discretion, or I'm not going to exercise it, and we've set that back, correct?
yes.
So, in answer to Judge Gore's question then, if he did not exercise the discretion where he had that right, that itself would be an abuse, correct? A failure to act.
His failure to act, believing that he didn't have the discretion to act, I suppose it could be.
We've sent cases back on that basis, if I'm not mistaken, so.
And I'm not going to dispute that. I don't have them all memorized. But I will say that if you look at the order and you look at the transcript, he carefully considered what was before him. So this wasn't the first thing out of his mouth was, I don't have the ability to act. The first thing out of his mouth was going through the 8 statutory factors.
Do you at least agree that the petitioner for the records at least has the threshold obligation to bring themselves within the statute, within their request?
Yes.
Okay, so going back to our guardrails, if that burden is on the requester, the petitioner for the records, then what happens then? I want everything in 5 hours, that happened within this time that affected these 2 departments. Would they be at that point within the statute to come back and say, you've got to be more specific. You've got to identify either specific people, a specific incident, a specific place. Would they be within the statute to force you to be more specific, like a bill of particulars, for lack of a better word?
I think I see your point, and I guess I would answer that in the affirmative. Here we asked for first, we described the march. We said from the first encounter till the scene was cleared.
So it was 1 day within 5 hours, right?
We didn't know, I did not know as the drafter that it was a 5-hour block of time. If I had said, we want all of the recordings made by Graham Police Department and the Alamance Sheriff's Office on October 31st and stop there, that's exceedingly broad. They're out on 85 ticketing people. They're doing what police departments and sheriff's offices do. I think that would be where we had that preliminary hearing with Judge Hanford on March 8th and said, well, we don't, what exactly are you looking for? This is really broad. Here, we were clear that we were talking about the march, and that's all that it's my understanding based on both the sheriff's office submission and the police department submissions. That's all they produced to Judge Hanford, and that's all he looked at. They weren't looking at a traffic stop out on the highway or something like that.
So let's say they were doing traffic control. They were preventing vehicular traffic from entering where the march was, and they had streets blocked off with just an officer standing there with his camera going. Would that be within the scope of your request?
It would be.
It would be?
Yeah.
Even though there was no interaction whatsoever with the parade, the guy's just out there to block street, just keeping vehicular traffic out of the way?
I think it would be, and I think it's consistent with the statute. We're to identify with reasonable particularity approximate time to approximate time, or otherwise, I don't remember, otherwise identify the activity with reasonable particularity sufficient to identify the recording to which the action refers. Okay. I think we've done that. I argued that to Judge Hanford, and I do not read the statute the way the appellants do, that I have to say, I want Officer Joe's interactions with this particular person. How do I know that it's been recorded? Mr. Stevens has been doing it a little bit longer than I have. I've been doing public record stuff, and we're the people that don't know exactly what we're asking for. We're asking for categories of information. I think this is consistent with that.
And what you said in the amended petition that's in the record is petitioner seeks release of all law enforcement and other recordings leading up to, during, and after the, quote, I am changed, close quote, march in Graham, North Carolina, occurring on 31 October 2020 from the time of the first contact was made with the march or spectators or media on that date and until the last member of law enforcement left the scene. Is that correct?
Yes. And it's my understanding that's what both the Sheriff's Office and Graham PD responded to.
Did the Sheriff's Office appeal this?
The Sheriff's Office is not before you. They've not appealed it. Oddly, the stay order covers their recordings. We do not have those at all. Judge Tyson, you asked.
But were there officers, were the deputies engaged, or was this pretty much a Graham police?
I believe it was a joint department effort.
Okay, so as far as you know, there were sheriff's deputies intermixed with the police department?
Without question.
Well, Mr. Miller can address that when-
Sure.
on rebuttal.
You asked a question about interviews, and do they fit that? I draw your attention to 132-1.4A, small a 6, and that's the definition of a recording. And the recording does not include any video or audio recordings of interviews regarding agency internal investigations or interviews or interrogations of suspects or witnesses. I can think of one particular instance, Your Honor, where it was the Harold Easter in-custody death in Charlotte. Mr. Easter was arrested and brought into the police station, and the statement of the police was that he went into medical distress and passed away in an interrogation room. We didn't know from context if he was being interrogated or he just happened to be being held there. Turns out he just happened to be being held. But in that petition, we added the citation to the public records law that I talked about before, that a court of competent jurisdiction could have released that. It turns out it was a non-issue. They weren't arguing that this was an interrogation. He just happened to be in custody in that room.
Well, G6 also says release would create a serious threat to the fair, impartial, and orderly administration of justice as well. So wouldn't that not, if there's a confession that was rendered during an interrogation, that probably would come within that catch-all too, would it not?
It could, and here Judge Hanford finding was that release would not create a serious threat to the pending things. I think that, again, I think that's evidence he was exercising his discretion, and so the abuse of discretion being so high, the appellants need to meet both prongs of the test. With that, unless there are any other questions, we do appreciate your time.
Any other questions?
Thank you,
Thank
Your
you,
Honor.
Mr. Toddy.
My pleasure.
Thank you, Mr. Stevens. Good to have you in court. Thank you.
Thank you, Your Honor. Two follow-up points, subject to any other questions the panel may have. If we had appealed from the trial court's initial order requiring submission of the video recordings for in-camera review, we would anticipate, and I think rightfully so, an objection that's an interlocutory appeal. The order wasn't final until the judge made the final order on the production. To say that you have to appeal these piecemeal, I think defies the concept.
Go ahead, I'm sorry.
I think it cuts against the strong policy of waiting until judgment is final and encourages piecemeal appeals, and would be very inefficient.
But your notice of appeal didn't reference that order either, did it?
We reference the order to produce.
You did not reference the earlier order. You referenced it by date, and you did not reference that date.
And in that order by date, the court repeats that same burden-sharing error when it says, I lack the authority, or the government failed to show a compelling government interest why I should censor, and I lack the authority. You have, both at the front end and at the back end, you have the same problem. The court shifts the burden onto Graham and says that we have to justify, or Graham has to justify, not producing. And then both at the front end and the back end, I don't remember if Mr. Toddy put it into the order, but he was very clear. I think it's the June 10th transcript, pages 27 and 28. The court found his reason for doing this was the desire for law enforcement transparency, the very reason Mr. Toddy put in his opening brief to the court why the court should release it. Again,
Did you seek the temporary stay and also the supersedis is in place?
did we seek it?
Yes.
No, Your Honor. Oh, we asked for yes, we did. We asked for a stay at the trial court. The Alamance County Sheriff's Office joined it. and the trial court granted the stay pending appeal.
So that was granted by the trial court, not by this court then, right?
Yes, Your Honor.
Okay.
And Alamance County is not appealed, is that correct?
That's correct. And the agencies were separate. This event started at a church north of Graham called Wayman's Chapel, and there was a parade march 7/10 of a mile long. There was an initial rally at Wayman's Chapel that was policed. The surrounding streets were shut off by the city of Graham. All of that was recorded and within the scope. The Graham Police Department, together with the State Highway Patrol, the route that was closed was a state highway for 7/10 of a mile. That was policed by the Graham Police Department. It is also within the scope of the request and within the scope of the recordings. That parade route ended north of the Alamance County Courthouse. This place is a focal point for civil rights protests because Alamance County still maintains a Confederate memorial there. And that's on the courthouse where the Confederate monument is where the Alamance County Sheriff's Office jurisdiction started, where all their activity occurred.
On the courthouse.
On the
ground.
courthouse. The courthouse sits in downtown Graham. There's a circular turnabout around the courthouse. Graham has to police everything around the courthouse. Alamance polices the courthouse itself. The violent interaction between Reverend Graham and the sheriff officer was on the courthouse grounds when the sheriff deputies seized his gas generator. So there were two departments that were working together, but in separate areas of responsibility.
Well, now, the old Graham Courthouse, the old Alamance County Courthouse, that is not the current, quote, courthouse, is it? Isn't there been a new one that's been built?
There is a new one, modern, generic, kind of like the one on Newbern, right around the corner here, not much to look at. I think they still do some proceedings in the old Alamance County Courthouse.
But there was nothing involving the actual current courthouse of Alamance County?
Actually, there was.
There was.
Because you recall, the petition says, from when spectators, media, or marchers were first encountered, that was when they arrived at Wayman's Chapel, till you were released, till law enforcement was released. Well, both agencies made arrests. The arrestees are then brought down to the courthouse, which also functions as the county jail. Several protesters moved down to the jail and protested there. So I believe at least Alamance County's footage goes all the way down to the new courthouse as well. It's a very, very expansive request, and we need to just go back to the words of subsection G. It says the request for release must state, not may, must state the date and approximate time of the activity captured in the recording, singular, or otherwise identify the activity with reasonable particularity sufficient to identify the singular recording. Nothing in that contemplates, which Mr. Toddy is trying to convert this into, a general public records request. We don't know what happened. We want to see everything that happened over this 5-hour period, over these multiple blocks between law enforcement and citizens that attended this event. While the ambitions may be noble, perhaps there are things noteworthy or newsworthy in there, this statute is not a public records request statute. It requires more specificity. It's narrowly written to request specific activities. If you knew somebody was arrested, request the videos showing that arrest.
You've talked a lot in your argument about the public interest. And would you address your colleague's argument that the public interest is number one of 8 reasons and that it's not an overriding interest that is anything? Could you address that?
I think that's wrong because there are 8 interests articulated. 2 are positive. There's only 1 that mitigates in favor of the release. I'm sorry, there's 2. Numbers 1 and number 8. Release is necessary to advance a compelling public interest. Numbers 2 through 7 are negative factors why the court should not release. And then there's number 8. So their common sense dictates that for the petitioner to change the status quo, there must be a satisfying of the burden, a reason to change the status quo.
Well,
that is in factors 1 or number 8.
What the statute says is in determining whether to order the release of all or a portion of the recordings in addition to any other standard the court deems relevant, the court shall consider the applicability of all the following. And one is the public interest. It goes all the way down to good cause shown, which seems to be a fairly broad catch-all. And I guess I'm trying to determine, and I'm sure Judge Tyson will give you sufficient time to answer my question. I'm trying to determine why a compelling public interest is any greater or than any of the others.
The others are just negative. So what I think my colleague argued was, if there's no reason not to produce it, it should be produced. We don't think that is what the legislature intended. There needs to be a reason to produce it. Factors 2 through 7 are only reasons not to produce it. The courts haven't interpreted, it's an issue of first impression, but we think simply come in and say, we're not aware of a reason. I mean, what petitioner is going to come in and create their own arguments against themselves? We don't know any reason why the law officers shouldn't produce all their cam recordings of their conversations at lunch, Monday through Wednesday, every day of the week. We can do this through 30 different requests, or I can just tell you we want all their lunchtime conversations. There's no reason not to.
I think Judge Gore has a request, and I'll give you a moment to sum up.
So on that issue, if there's more negatives, and I understand your argument, if the trial court still made that decision, what prejudice would get you to overcome that issue, would overcome the burden?
Well, in this case, the trial court specifically found risk to reputation and I think safety, risk to safety. The court found, and the newspapers have not contested in its discretion, the court found that there was harm in releasing, harm in the reputation of the protesters, harm to the people that were arrested, their privacy rights. These were very racially charged times. There were people making a lot of incendiary allegations against officers, that Reverend Drumright was arrested not because of a generator, but said he was arrested because he was protesting police brutality against minorities. There were a lot of members of law enforcement at the time that they live in this community were concerned for their personal safety. So the court acknowledged there were significant risks in releasing that. So I think that threshold has been met, but then said, I lack authority to do anything about that, and that's simply not the case.
What would you have the court do?
Your Honor, we would ask the court to reverse and remand the trial court, remand back to the trial court for a rehearing, reverse with the instructions that these corpus-style requests fall outside the scope of the statute, and that in a rehearing for specific recordings, that the petitioner must cite a public interest beyond transparency in support of the burden of production.
Thank you.
Thank you, Your Honor.
Thank you for your arguments. Mr. Farland, will you please adjourn court?
All rise. This session of the North Carolina Court of Appeals is now adjourned.